I don't advise that you estate plan in a box, go online and don't ask AI, what should I do with my estate plan? You really do need non-hallucinated knowledge of the cases in your state. And that's what estate planning lawyers provide.
Welcome back to the Retirement Fiduciary Podcast, a place where we have authentic, no BS discussions about retirement planning, investment strategies, and wealth management. Whether you're approaching retirement or if you've already made work optional, this show is for you. Now, here's your host, Adam Koós, President, Portfolio Manager, and Senior Financial Advisor at Libertas Wealth Management Group at libertaswealth.com.
All right, everybody. Today's guest is Professor Kelly Lise Murray. Kelly's a lawyer, a mediator, and legal scholar who spent nearly 2 decades teaching law at Vanderbilt University. We've got March Madness upon us right now, so that's pretty important for Vanderbilt, or Vandy, right? But she did so before shifting her focus to wealth dispute resolution. She's also the host of the Wealth Litigated podcast, so be sure to check that out. She breaks down real courtroom cases involving trusts, estates, family wealth disputes, or what she calls all the drama in true crime without the blood, which I love. That's hilarious. Now, our hope is none of our listeners ever end up in these situations, but these cases are great learning examples of what can happen when planning isn't done correctly. So, Kelly, thank you so much for joining the show. We were talking offline about how I couldn't wait to meet you and interview you because this is going to be really interesting.
Thanks, Adam. We have a really great conversation set up.
And it's one of those things that I think that people don't want to talk about, right? I've seen attorneys stand on stage in front of 1,000 people, financial advisors, and say it's not a matter of if, it's when you get involved in some sort of litigation. And of course, we all scoff at it, right? Like, it's not going to happen to me. But your tagline, all the drama of true crime, but without the blood, would tell me more about that. What led you to leave academia and start breaking down real wealth disputes for the public with that tagline?
The common thread is money litigates. And it's personal dynamics. And if you think about it, wealth planning, wealth growth, wealth protection, what are the mechanisms you use? Before marriage, it could be a prenuptial. During marriage, it could be a postnuptial agreement when things change. Divorce, you've got folks who pre-plan the divorce before filing, get their financial information ready. You have estate planning, which if you don't make sure all of your documents, all of those legal mechanisms coordinate, they could conflict. And then upon passing of one spouse or the other, if a marital or a family trust becomes irrevocable when the first spouse passes away, that's another example of things that can turn into litigation. And I just want to say, all the drama of true crime without the blood, crime does not pay. You do not get the life insurance if you are involved in the death you want to. So definitely want to make that clear.
So a lot of what we talk about on this show is how to protect families and avoid costly mistakes, whereas your work focuses on what happens when those plans fail, obviously, and end up in court. I'm just curious, what drew you to that niche after what you had done in the past?
It was just a few years into my time at Vanderbilt Law School, and I was looking for a focus for my legal scholarship because we were encouraged to teach continuing legal education and outreach and all of those things. And someone raised a question that I didn't know the answer to. And I thought, I've got a workshop. I have a 1 hour. There were so many things I found that were going wrong that it turned into a side business, not just legal scholarship, but actually monetizing that legal scholarship. And so for the whole time I was teaching at Vanderbilt, I had this side focus, which is now my main focus. And mainly, people don't realize until it's too late that these things can lead to litigation. So my focus was real property dispute resolution. What do people sue about, for example, after divorce regarding the house? That's how I got started. But it's broader than that because all of the cases that are appealed, property division is permanent. So why is someone so upset that they're willing to spend 2 more years and tens of thousands of more dollars in legal fees to probably lose on appeal? What are they so upset about? Those cases included the house, retirement and quadro issues, family closely held business issues. I just focused on the real property. And now since retiring from academia, I'm expanding. And that's why it's broadened to Wealth Litigated.
Nice. And just so everybody knows, quadro stands for Qualified Domestic Relations Order, which is when you're in a divorce and somebody has a retirement plan, pension, deferred comp even, and it's not necessarily portable in a normal circumstance. When you get divorced, you can get access to that, obviously, through litigation or through the divorce. But
It's the only way.
You mentioned blended families. So I think that's a good place for us to start. I think more than 50% of people get divorced these days, right? And many of them have children. Many families today have second marriages, blended families. So from a legal perspective, what are some of the biggest estate planning mistakes that you see in those situations?
The biggest mistake is to not change your estate planning documents before and after the second marriage. For example, if you change nothing, you get married, it's your second marriage, that new spouse has an elective share, which takes precedence over your will. And it may not be what you intended your assets, how they were going to be distributed, especially if you have children from a previous marriage, whether they're minors or adults. And we're seeing that in the litigation. So that's one issue. But then also, who are your beneficiaries? If this is a second marriage and you were divorced from your previous marriage, is your former spouse still named as the beneficiary? Depending on what type of asset it is, your ex may inherit. Or even worse, your ex-in-laws may inherit. Many states have statutes that disqualify a former spouse even if you don't change the name. Now, not with private contracts, but with wills and other documents like that. But it doesn't necessarily disqualify your ex-in-laws, depending on what's in your will. Would you want your ex-in-laws to inherit your house?
Yeah, probably
not.
I don't
think so.
No.
But those are the reasons why coordinating and getting legal advice. You should, if you have wealth that you want to protect and you want to have it grow and benefit the people you want it to benefit, you need legal advice for your wealth planning. You need financial advice to grow that wealth, but you also need estate planning and you need it coordinated. That's the biggest takeaway of our discussion today. The coordination, the lack of coordination leads to litigation.
Yeah, we always talk about we always get asked, what's the biggest mistake or what's the biggest takeaway? When I'm on podcasts, he'll say, at the end of the day, what's the biggest takeaway for people and the public? And it's always just to have a plan. And I know it sounds so boring and cliche and there's nothing super sexy or exciting about that, but it's the old, people don't plan to fail, right? It's such a cliche. And you mentioned legal documents, inheritances, things like that. One of our infamous stories we like to tell is about the guy who got divorced and remarried and then was in the hospital and non-responsive, and his ex-wife was the healthcare directive. And you
may not want that.
You probably don't want that. Yeah. And some of your materials, you mentioned a recent Ohio case, actually, Marinakis versus Marinakis. Is this something about where the father remarried and his children from a first marriage ended up in court? What happened in that case?
So in this case, actually, it was his siblings. I gave you a lot of cases.
Yeah.
And that's why we have to look at all of them, because the facts change, the money changes, and then the court's analysis of those different material facts changes. In this case, the father changed his will 1 month before getting married. There's no divorce involved.
Okay.
They have 3 children, and unfortunately, he passes away in 2021 from COVID complications.
Ooh.
At the time of his death, his 3 children are 11, 8, and 1. His estate is his wealth is $10 million. His probatable estate is $5 million. And his widow is able to take 1/3 of the probate estate as her elective share. And I mentioned that before.
Ooh.
If you don't provide for your spouse in your state, she may have a statutory election to get 1/3 or more, depending on whether there are children. And so that protects spouses from being disinherited unless you actually go through the process of disinheriting your spouse and it's not marital property. So here the widow is taken care of. The children during his lifetime, even though he didn't change, his will benefited his siblings, but his children received significant amounts in lifetime wealth transfers. So about $3 million total, and then $750,000 each. After he passed away, the widow filed for pretermitted heirs. She was claiming that her children were accidentally excluded, that he should have changed his will, he never did, and it was an accident. And if that holds up, his children would inherit intestate, meaning as if he had no will, and that would disinherit his siblings. So his siblings sued because there's $5 million at stake.
Okay.
And the trial court sided with the widow and the children, and as you would expect, these are minors. And he accidentally, there's nothing written that he didn't write, I intend to disinherit these relatives, these blood relatives. If you want to disinherit someone, you have to be specific about it, because these statutes of intestate succession, I didn't make a provision, so the state will decide how my assets are divided.
Yep.
But so they win at the trial level, but it gets reversed on appeal. Doesn't mean the widow and the children lose. It means it goes back, because the factual argument by the siblings actually needed more investigation. And the argument was this: a pretermitted error, an accidental, I left out my kids from my will, they were actually provided for. And one of the provisions was $3 million. Were they accidentally left out? That's the siblings argument. And that's why it gets reversed. And it went back down for a trial. So it either settled or no one appealed the trial result.
Wow. That's interesting. And you also referenced a California case, not an Ohio case, but a California case where the outcome went the exact opposite direction, where I think a stepchild was allowed to inherit from the step parent. What happened there?
This is why you need legal advice, because every state is different. So your mileage may vary. In California, they have a particular statute. This father was married 3 times. First marriage, 1 child biologically. Second marriage, 1 child biologically. Third marriage, stepson.
Okay.
The biological children opposed the stepson's claim to inherit as a natural child from his natural parent. And the litigation revolved around the definition of natural parent, not adoption. How are you a natural parent not by adoption? And the court ultimately held that given the relationship and the evidence of, for example, this actual father referring to the stepson as his son to his close friends throughout his lifetime, even after the 3rd divorce, the court held that the stepson was a natural child, and because he met that definition, he could inherit.
Got it. And that's interesting too. Now, if we just step back, because these were so different, obviously the outcomes were different. When you step back and look at these cases together from a 30,000-foot view, what are the big planning lessons for families, people watching, listening, to try and avoid these kinds of disputes?
Clarity. What do you intend? And just because you are clear on what you intend doesn't mean your documents match that clarity. You need to match what you intend to happen with the documents you have in place, or you need them legally revised. And this is not estate planning in a box. This is not using AI to write your estate plan. This is getting actually licensed legal advice from a lawyer in your state to coordinate depending on which life cycle events are added. If you never get divorced, you won't have that changing or challenging your estate planning. But if you have been divorced, if you are in a blended family with a second marriage, you need to find out where you are right now. Because if you didn't change anything, have the second marriage, your current spouse has statutory rights that may conflict with your will, and the statute will prevail.
Yeah, it's scary, and it's not funny, but it happens so often.
It's easy to overlook. And that's why these litigated cases show us what else we need to look for. I don't want this to happen to anyone else. And that's why I have spent over 18 years getting the word out about these cases, so you can learn from these mistakes. You don't live these mistakes.
I think so many times it happens because estate planning is one of those things that people just put in the background. They don't want to think about it. It's for our office, we have almost 400 clients. I've been doing this for 25 years. And the number one most procrastinated financial planning item is estate planning, without a doubt. It's easy to see how somebody could get divorced, get remarried, and just say, oh, I'm not going to worry about that. Or maybe it doesn't even come to mind. Yeah.
Any and all of the above, but the consequences could be conflict. And then there will be litigation to determine which document prevails or which statute overrides anything that you actually wrote and wanted to have happen.
Time and money.
That's right.
Let's change gears here, because I'm in the process of I think I've finally convinced my 73-year-old parents to set a trust up. So they're in the process of doing that. It's never fun, especially when you're this oldest son and you're also a financial advisor and you're talking about pretty sensitive issues here. But I learned a lot in these meetings, even though I've been doing this as long as I have. And I'm pretty dangerous being a CFP and knowing a lot about estate planning. But as I'm sitting in the attorney's office, I'm listening to these stories about how if you want to have an irrevocable trust, but you've got even a small HELOC on your property, your home, in order to put it in an irrevocable trust, you have to ensure that the bank isn't going to call the loan, because as soon as it gets thrown in the irrevocable trust, now all of a sudden these banks are saying that they're going to call the loans. And worse, they can say that they won't call it in advance and get it in writing. And it doesn't matter if you do it and they change their mind. The paperwork doesn't matter.
This is so important. I've been teaching this since 2008. There's a statute called the Garn-St Germaine Act, and it lists events, the transfer of real property title from divorce, from one spouse to another, from death, the parent to a child, or the husband, the spouse to another spouse. Those don't trigger the acceleration clause. So the mortgage is not due. And this is one piece I just want to put out there. If you inherit a house this way, you do not have to refinance the mortgage. As long as you can pay the mortgage, the Garn-St Germaine Act protects you. You don't have to refinance it. So that means your credit isn't relevant, your income isn't relevant, as long as you meet the mortgage payment. But there's only one type of trust that is protected like this. If you create the wrong trust, the mortgage is due in full the moment you transfer title from your parents personally to their trust as the vested titled owner. And this is critical. You have to get all this information before you transfer title. And it's not just that. So the mortgage, major issue, you don't want it due right now. No, and a home equity line of credit, instead of paying for the first 10 years before it matures, you're paying interest only. Mm-hmm. If the home equity line of credit accelerates and is due in full, now you owe the whole amount right now. That's a totally different picture. But another issue from this exact same legal structure is your property and casualty insurance. It's personal. Property and casualty insurance does not insure your house. It insures your insurable interest in your house.
Okay.
If you are the named insured and you want to transfer title from yourself to a trust, the trust is not the named insured, and people don't do anything with their insurance. The house burns down and the insurance company can deny the claim and they will win in court.
That is really interesting. I've never heard that before.
This is one of those OMGs that I found in 2007 that we have to get the word out. Back in 2007, I thought, I'm too late. People have already talked about this. Everybody knows. All these years later, I'm still talking about it because we haven't gotten the word out enough. You should be considering these structures, but you need to make sure you do it in the right order, and you don't want to divest yourself from title without this pre-planning. It's critical.
That is super interesting. Never heard that. You've heard a lot lately this past 3-4 years about what the acceleration in home values across the United States, that people haven't updated the value of their home. So their house burns down and they're only getting 75 cents in the dollar because they never updated the value of the home on the insurance policy.
Because it's a contract and they're contracting for risk. They would charge you a bit more. You know what? It's worth it.
Yeah.
Because
tell me about it.
If your house is appreciated hundreds of thousands of dollars and $100 more in premium or whatever it is, it's still worth it, because if your house burns down, it's not replacement cost. It's what you insured it for.
Yeah. Speaking of trusts and the legal matters here, let's talk about another story. Let's talk about what happens after the first spouse dies. There was a case right here, Franklin County, Ohio, that's Columbus, Ohio, the capital, Collins versus Flannery, involving a trust created by the husband and his second wife. So walk us through what happened there.
So in this case, they were going through a divorce when he died. There's an extra complication. If you're going through a divorce and you don't finish things, the assets transfer not pursuant to the divorce, but pursuant to how you have things set up. And that may not be what you intend once one or the other starts the divorce proceedings. This trust became irrevocable upon his death. The wife had a life interest. She was the only trustee. She didn't answer to anyone. She was in control of what she spent. There were some guardrails, and basically the trust becomes irrevocable. She's the trustee, but he has 2 adult children from a previous marriage, and they want to know what's going on. Yeah. They sue. She and her lawyers argue she doesn't have to tell you anything. She doesn't have to account to you. You don't have standing. That's the first issue, because they are contingent remainder beneficiaries. The stepmother's argument is, you don't know if you're inheriting anything. And if you don't have a vested interest, you can't challenge me. Now, the court actually held that his adult daughters, her stepchildren, did have standing. So that's the first hurdle. Can you even sue her? Second hurdle was, can you force an accounting? What would circumvent all of this? Being clear in your trust documents that whoever is the trustee has to give your adult children an accounting. But anyway, that wasn't written in necessarily. Adult daughters do prevail on that issue as well, but they lose trying to remove the stepmother as the trustee. And she's not just the stepmother, she was the person who was going through a divorce with their father. And so if this trust was not structured in a way to protect the inheritance of the adult daughters, can the second wife deplete it? Or are there guardrails? The court held that there were guardrails, but a concurrence. One judge on the panel agreed with the result, but had a different legal view. He concluded that the guardrails were illusory in this case, and that the stepmother really could deplete the whole trust. And that if she did that, the adult daughters would inherit nothing.
Wow. So
it's pretty scary.
So stepmom is essentially arguing the children have no standing to challenge what she's doing with this trust, right?
Yes.
And the court ends up in the end disagreeing.
Right. But they had to litigate to prove their standing. It would be better to be clear in the trust documents.
Sure.
There are steps you can take. And the other takeaway from this is it's not assuming the worst of your second spouse. It's about removing that obligation to create a structure of accountability where it isn't, because what if your second spouse is doing everything right, but one of your adult children is just trying to stir things up? It's equal opportunity shenanigans. It's not always the stepmother. It isn't always. Sometimes it isn't. But if you structure it in a way that she is not the sole person in charge of everything, then they can't sue her. There's no reason to sue her. And the flip side is you're also protecting your adult children. So when you're clear with who is, do you have a co-trustee? Do you have a professional trustee? So do you have a third party, a lawyer or a corporate trustee, so that it isn't even your spouse? Because they're supposed to be disinterested, more objective, and can provide the accountings and all of that. So it's all about the structure, really, to avoid this. And you can just see how this set up. If I didn't tell you that they were in the middle of a divorce when he died, we would all view this case differently. But once you hear that they were getting divorced, what was the perspective of his adult children from a previous marriage?
Sure.
She was almost out. And
changes everything.
The divorce changes a lot, but it's still a good idea, even if you're not divorcing, to take this structural pressure off of the surviving spouse. It is still a good idea.
Oh, yeah. Just, peace of mind, if for nothing else. Yeah. So kind of like when we were talking earlier about blended marriages, I want to bring up a second case that it was in your materials here, the Texas case, where the trustee was actually using funds in the trust for their personal expenses.
Very personal.
including a divorce attorney and donations to a YouTube preacher.
And a car. She bought a car. She did everything you're not supposed to do. She did. And it's even worse because this trust was set up by the mother to benefit the disabled brother. So it's even worse.
Oh, wow.
These are funds that are supposed to support a disabled brother. The sister's the trustee, but there is a successor trustee. That's always a good idea. The successor trustee stepped in on behalf of the disabled brother, and the sister, who was the trustee, argued lack of standing. She also argued that the Texas court had no jurisdiction over her personally because she lived in a different state. And then she defaults because the financial misuse evidence was so overwhelming. She doesn't appear. She doesn't challenge it. And so ultimately, the successor trustee is appointed. She's removed. That's the right result. It would be better to have guardrails so that something like this doesn't happen.
Yeah. In both of these cases, obviously the problems were eventually caught, but only after litigation. And I think it's some of these things, the trustee things come up before, where people, what if I'm gone and the trustee spends my money for their own personal expenses? Who's going to catch them? How would anybody know? So this is a real concern that people have. What could have been done in these cases in their estate plan in advance to prevent these conflicts from happening in the first place?
One is a co-trustee. If you want your spouse to be the trustee or your spouse is demanding to be the trustee, a co-trustee is a structure where there's more accountability and more peace of mind, as you've been describing it, where the surviving spouse isn't the sole person and has backup for a contingent remainder beneficiary like adult children or something. They could contact the non-spouse trustee. So a co-trustee structure, or straight out a professional fiduciary.
Okay.
You could set that up. And then the third one is rather new. Ohio does allow this. Not every state does. A trust protector. I saw this in an Arkansas case where the trust protector was the mother-in-law. And that really vexed the surviving widow because it wasn't her mother. It was the mother-in-law who was the trust protector. But a trust protector is usually a third party, a lawyer, a financial professional, a professional fiduciary.
Yeah.
And they're not the trustee, but they are like chairman of the board. It's just a little bit more accountability.
Yeah, a little bit
so
different.
Those are some structures to think about.
And if a client says, my spouse is just going to control everything if I die, what kind of follow-up questions should the advisor be asking?
The first thing, I would like you to have an actually litigated case to give as an example.
Okay.
That way, no one has to be the bad guy.
Sure.
State specific, where the facts are the surviving spouse isn't the shenaniganer. Remember, this is equal opportunity. Sometimes it's the beneficiary, sometimes the family trustee, but it's equal opportunity. Whereas if she's doing nothing wrong, but one adult child, and if it's a stepchild, is disgruntled, what kind of pressures will she be put under?
Right.
So it's really, it should be framed as a structural support, not a condemnation of their financial budgeting abilities or anything like that. Just, this is a structural support to prevent litigation, which would deplete the estate, is really how I would frame it.
Okay. No, that makes sense. And speaking of depleting the estate and expensive mistakes, there is no shortage of great stories. I shouldn't call them great, right? That's probably not the right word, but expensive stories, we'll just call them.
That's a great phrase. Expensive
famous expensive stories. We've been doing speaking engagements since 2007 when we talk about these famous cases that a lot of people have heard of. But you had mentioned specifically a national case involving a missed checkbox on an estate filing that cost a family over $800,000. So let's go over that. What happened?
We need to talk about this. All right, this one is the estate of Griffin versus the Commissioner of the Internal Revenue Service. So this is a federal tax case, and there were two critical errors. A Q-TIP trust. Basically, a Q-TIP trust is funds that are reserved for the lifetime of the surviving spouse, but she can't touch the principal. So she can use it up until throughout her life, and it's income from the assets. She doesn't touch the core of the assets. In order for a Q-TIP trust to work, you have to file your estate tax return on time, and you have to check the correct box. That's critical. If you fail to do that, it actually goes into your taxable estate and it isn't separated from your taxable estate. This used to be a bigger issue when we had lower exemptions. Now that the exemptions are higher, this may be less of an issue, but it was a significant issue in this case. So what happened was when the estate tax return is filed, they did not check the box for a Q-TIP trust. And because they did not make the Q-TIP election on time, it can never be fixed. You have to file your tax return on time. You have to check the box. Otherwise, and so $2.3 million was listed as all other property instead of the Q-TIP trust. So the $2.3 million was supposed to fund this income for her because it was listed wrong and the box was not checked.
How does something like that even get missed?
This one is in execution. Setup also had structural problems, but the mistake we just talked about was in execution. Basically, whoever is filing the tax return on behalf of the trust, someone else should be looking at it. There should be a checklist of sorts from the estate planning attorney to say when the estate tax return is due, check, make sure, confirm that these steps have been taken, including checking this box and not listing the Q-TIP assets as all other property, because that defeated the Q-TIP election.
You keep calling them guardrails, but safeguards should be in place to make sure details like that don't fall through the cracks.
The guardrails are in structuring it in the first place, and this is execution. So I would put this one under execution. At least 2 sets of eyes before that tax return is filed.
Okay, fair enough.
So this one would be someone else who knows there is a Q-TIP election that's supposed to happen. And, sidebar, there's a statute of limitations for the IRS to challenge your Q-TIP election. After 3 years, even if you've done something wrong, they can't mess with you. I found this out by covering an Arkansas case. And so there's a 3-year, and then after that, you're fine. So you have to do it right the first time. And then even if you did it wrong, but the Q-TIP election was authorized after 3 years, the IRS cannot revoke it.
So just start the clock, right?
That's right.
Start the clock and wait. Twiddle your thumbs. Let's talk about prenuptial agreements. Sensitive topic, obviously. We just did a business valuation last year for an owner who was entering her second marriage, and she just wanted to make sure we had an accurate valuation of the business before we walked into the second marriage for obvious reasons. And you had mentioned that there was also an Ohio case involving a prenuptial agreement that was thrown out because of how it was executed.
And it was husband and wife before they get married. The husband is a lawyer, and he's the one who wrote the prenuptial. He's the one who should have known better. And his prenuptial that he had her sign the day before the wedding. Now, these are not guaranteed to defeat a prenuptial, but they're not good. Day before the wedding, no opportunity to get independent counsel to review, drafted by the husband and not by an independent party.
Yeah.
All of those, the power imbalance, because he was a lawyer, was also held against him. And so she didn't even need to get to unconscionability. He loses on overreaching. And this case in Ohio basically confirms what appellate courts do all the time. If they can resolve your whole case with one issue, they will not reach the rest of it. They don't need to do advisory opinions. They only finish what is needed to resolve all the active issues. And if they can do that with half of your argument, they will do it. And that's what they did here. So she proved overreaching. Prenup is out.
Minimum effective dose, right? Minimum effective dose.
That's right. That's right. And so the takeaway from that particular case, it may not be required that your spouse, your soon-to-be spouse, have independent counsel, but it's always a good idea.
Yeah.
It may not be required that you have minute specificity, but like your example, revaluing the business right before the prenuptial is signed is a current valuation and not a 3-year-old valuation.
Correct.
Because that's what gets litigated. Think of it as avoiding an investment to create an enforceable prenuptial that avoids litigation. It's like a deterrent. The prenuptial is supposed to be a deterrent. If it's executed correctly and written correctly and structured correctly, it should work that way. If you end up getting divorced, it is a cleaner litigation because you have it all planned out. But if you do things like this Ohio example, it won't work out. And then we have a New York example too, which is being cited as changing how prenuptials are evaluated by court. So it's significant.
And Ohio only began allowing prenups in 2023. And that's not that long ago.
I was surprised to see that. So I don't have all 50 states on all issues memorized. And when I learned something new, that definitely surprised me. 2023.
Yeah, I'm same boat. I feel the same way. It's hard to stump me these days, but when I'm stumped, it's pretty exciting. But
exactly. Hey, news you can use in Ohio.
That's right. It's a learning opportunity. So for those couples who signed prenups years ago, should they be updating these agreements today?
Here's another issue that I just came across recently: portability. If you move, if your estate plan, your trust, or your prenuptial are structured for the state where you are, but then you move and divorce in a different state, it may not work the way you expected, or it may not work at all.
Yeah.
If you move, you need legal analysis of all of these documents. These, I call them wealth life cycle documents. You need to make sure they don't conflict, and you need to make sure how they're going to work in your new state. Because you can move from Ohio to California. California's community property works differently.
And I think that's another thing a lot of people don't know. They set up their estate in Indiana, and then they move to Florida. They retire, and they move. They go, instead of snowbirding, now they're going to permanently move. And now their estate plan's inapplicable at this point. It needs to be redone. Yeah. So we've talked about disputes after somebody dies. What about situations where someone becomes incapacitated? I talked about the story we had of the client who was incapacitated, non-responsive in a hospital, and the ex had the healthcare directive still. What should families be thinking?
When you're your former spouse, what we need to do is, as part of the divorce, you need to look at all of your documents where your former spouse's name is and confirm with your divorce lawyer and your estate planning lawyer what needs to be changed and when it can be changed. In some states, you cannot change key aspects of your estate planning during the divorce. You can't. Everything's frozen, either by statute, like California has a statute, an automatic temporary restraining order, but other states, one party could ask for a temporary restraining order. So there could still be a TRO preventing you from making these changes. But you need to have this conversation so that during the divorce, you are divorcing someone who may not be happy with you. You don't want that person making your medical decisions. Normally on the forms, they list backups, but if you don't make the change, the first person they're going to call is the person you're divorcing or your ex-spouse because you didn't make that change. So this is part of the assessment you need of all of the documents that pertain to you financially and legally. And this healthcare is personal and legal, meaning who can make these medical decisions for you.
Very personal. And speaking of assessments, if somebody's listening, watching this today, and they're looking to reduce their chances of their family ending up in court someday, what would you say is the one step they should take this week? Right now, what should they put in the email themselves or put a note down, post-it note on the fridge for?
I would say an estate planning lawyer would be the hub of who can direct you to what they can help you with, but what else you need and what else you may need to change. They can coordinate with your wealth advisor, your financial planner, your accountant, all of those folks. But I would start with an estate planning lawyer. And
you mentioned the financial advisors, wealth advisors. What about them? For those watching, listening that are professionals, what's the one big takeaway or big question they should be asking their clients during review meetings to help prevent these kinds of disputes, if it's not the same thing?
It would be great for you to help inventory what I'm calling the life cycle legal documents. You should ask your clients, what do you have? Let's identify the gaps. And then the client can go to the appropriate lawyer to identify how they might fill those gaps legally. I don't advise that you estate plan in a box. Go online and don't ask AI, what should I do with my estate plan? You really do need non-hallucinated knowledge of the cases in your state. And that's what estate planning lawyers provide. And estate planning lawyers are great in their business model, just the way real estate lawyers are. They have mastered limited scope representation. They're not going to charge you a litigation retainer because they're not going to court. They will diagnose what you need. They will tell you what it costs.
Where can listeners, people watching, learn more about you online? What's the best way to contact you?
The best place is wealthlitigated.com. We have our podcast there. We're also coming out with newsletters, news you can use. Of course, everything I do is an actually litigated case. But we're making it broad so it's not just one type of litigation, but it affects all assets throughout what I'm calling this life cycle, this legal life cycle of your wealth.
And that's what I loved about what we talked about today, is that this a bunch of stories, cases, real life cases, not just made up stories, obviously. So I think this was incredibly helpful, not just for families, individuals watching, but also for financial advisors, professionals in our industry, my peers, who want to make sure that they're doing what's right for their clients to avoid these kinds of mistakes down the road. For those listening, watching, be sure to check out the Wealth Litigated podcast. And if you'd like to learn more about Kelly and her work, you can check out not only the podcast, but her website is wealthlitigated.com and then vettingthehouse.com. And we'll also include those links in our show notes. So Kelly, thanks so much again for joining us. And as I always say, there's thousands and thousands of podcasts out there, and you chose to give ours a listen today. So thank you so much for joining us, and we'll see you next time.
We hope you enjoyed today's episode. If you like a second opinion on your retirement plan or investment strategy, please head over to libertaswealth.com. This podcast is for informational purposes only and should not be considered as legal, financial, tax, or as a basis for investment decisions. Always consult a certified financial planner or a fee-only fiduciary advisor before acting on any ideas discussed.